Hello and welcome to Runkle of the Bailey, a new legal information education channel. My name is Ian Runkle. I'm a criminal defense and firearms lawyer, and this is my first video, so I hope you'll bear with me as I expect there will be a lot of rough edges. So this video is about a letter that the RCMP recently sent out. It's titled Firearm Registration Certificate Impacted by the Amended Classification Regulations. Hopefully I should have a copy appearing up on the screen shortly, and that'll depend on my editing skill here. Now, what this letter is about is you will have gotten this if you had a registered firearm that the RCMP think is covered by the new ban. That's almost entirely going to be restricted firearms because it's very unlikely that you have a non-restricted firearm that's registered. There are some rare circumstances where that can happen. I might cover that in a future video, but for right now we'll just leave it that it's a very rare sort of event. Now, if you got one of these letters, it actually details which firearms they think that covers. And one of the interesting things on this, it provides a bit of background. This is just by way of explanation here. So it talks about the amnesty order. It provides the information that the amnesty order expires on April 30th, 2022. So if you're a gun owner, you want to have that in your calendar, probably with a little reminder ahead of time, because your rights will greatly change on that date if you have these, because that's a date when criminal liability kicks in, unless the government has done something else. So there's also some details about what you can do with one of these guns if you have it, which is almost nothing. You can't take it to the range. You may be able to take it hunting. There is an exception for subsistence hunting or aboriginal hunting, but those exceptions are quite narrow. So I am really cautious in recommending anyone take advantage of those. Speak to a lawyer if you think that applies to you, because there are a lot of pitfalls that possibly apply there. But essentially, you are just stuck with these things until you either dispose of them by some fashion or something else. So the interesting part of this letter is where it notes, and this is at the last line of the sort of first block of text. It says, these firearms listed below are now classified as prohibited, and the previous registration certificates are automatically nullified and are therefore no longer valid, but should be retained as a historical registration record. So hopefully I'm getting that up on the screen nowish. All right, so you can see that little line there. Now, this is very interesting to me in terms of the meaning of this statement, because they say it's automatically nullified. But a registration certificate isn't just a piece of paper. It's a legal document that's created by statute. So the meaning of this document is defined in law. And there's also definitions for when they can revoke it or cancel it and under what circumstances. So unless they're following the rules, some sort of legal process, they can't just decide that they want to cancel these things for no reason. So I'm a firearms lawyer. I tend to be fairly up on firearms law. I couldn't find anything anywhere providing for the automatic nullification of these registration certificates. It doesn't appear to be in the new ban. It doesn't appear to be in the amnesty order. It doesn't appear to be anywhere. So let's cover the legislation a bit, and hopefully that'll be coming up on the screen shortly. And the main aspect here is there's section 72 sub 1 of the Firearms Act. And as you can see, it notes where they decide to revoke a registration certificate, they shall give notice of the decision in the prescribed form to the applicant for or the holder of the license, registration, certificate, or authorization. Now, there are some exceptions to that. And I'll back up a little bit. Where it says shall is legal language. So in law, you'll see shall and may come up from time to time. May refers to something that's in the discretion of whoever has the decision-making authority there. So if the law says that they may do something, then it's their decision as to do it. There are some rules and legal principles that apply how they can make that decision and how they can't make that decision. But where it says shall, which is what we see here, There isn't any discretion. It's something that they have to do. They must do it. They don't have any other option. So here we see that strong shall language. It's very different than the may language. Now, we get into the exceptions. When notice not required. So these are exceptions to that requirement for notice. The first exception is if the holder of the license or registration certificate or authorization has requested that it be revoked. So the usual circumstance there is somebody who has a firearms license. They decide they don't want to have a firearms license, and so they ask that it be canceled. There's good reason why you wouldn't have to send out notice for that, because you've asked for it. You know why it was revoked. You don't need to know how to appeal it. You don't need to know why that decision was made. All of that information is already in your hands. And so the next clause is that they don't have to give you notice if the revocation is incidental to the issuance of a new document. So as the most common example, if you renew your firearms license, they're going to issue you a new one, but they're also going to cancel the old one. They don't have to give you notice of why that old license is canceled. You already know why, and you have a license in your hand. So you're not going to need to know how to appeal that. So that's why they don't have to provide you with notice in the prescribed form for those circumstances. Now, the law specifies what material has to accompany notice or accompany the notice. That must include the reasons for the decision, disclosing the nature of information relied on for the decision. So what that means is that they have to explain how they came to that decision. In this case, it's going to be fairly easy. They're going to say, we came to that decision because the law changed and now these guns are banned. But normally they'll have to provide a bit more reason for this. Where this often comes up is if they think you've been violent somehow. So, you got into a fight at a bar and now they want to take your gun license because they think you're a dangerous person. They might say, here's the details. This is what we think. We think that you're an angry, dangerous person. And we think that because we relied on the police report, we relied on the statement provided by the guy you got into a fight with, we relied on this other information. And all of that is there so that you know that the decision was made fairly, which we hope it is, and so that you can decide whether or not you want to challenge that decision. Maybe you have other information that's in your possession that can contradict that. So that's why they provide those details, so you can understand what they considered and by implication what they didn't consider. So the other thing that they have to include is a copy of sections 74 to 81 of the Firearms Act. 74 to 81 of the Firearms Act covers your rights to challenge this decision. It's a very special provision of the Firearms Act because it sets out its own process for challenging the decision of the Chief Firearms Officer. So you might be wondering, why has he spent all this time talking about sections 74 to 81? Now, that gets to what this letter is so strange and why I think it's very problematic. So it says that your registration certificates are automatically nullified. Again, I don't know of any way that these registration certificates can be automatically nullified. There is a provision for automatic canceling of a registration certificate, but it really doesn't apply here. It covers a very unusual circumstance. And that circumstance is if you have a converted fully automatic firearm, which means a firearm that was fully automatic but was converted to fire semi-automatic or converted to fire in some other action other than automatic. If you go and you change the firearm so that it fires fully automatic again, that automatically cancels your registration certificates. So it's a very specific, very unusual circumstance, and it's not covered by this new situation. So why would they tell us that these are automatically nullified if that's something that they can't do? And what it seems is that they're trying to get around the ability to have these challenges. They're trying to avoid providing proper notices of revocation, and they don't want people challenging these things. And in my view, that's improper. And in my view, that creates an interesting situation because you have a limited period of time to file a reference to a provincial court judge. That's covered in section 74 sub 2, and it notes that you can only refer a matter to a provincial court judge within 30 days after receiving the notice. Now, that's not a hard limit, but you should treat it as if it's a hard limit. The reason why is that there's an exception to that that says, or within such further time as is allowed by a provincial court judge, whether before or after the expiration of those 30 days. So the provincial court judge can allow you to file outside of those 30 days. However, you'll see that it's immediately harder to win if you're filing outside of those 30 days, because where before you only had to show one thing, which is that the decision is wrong, and it has to be sufficiently wrong that the court's going to interfere with it. And the test for that is a bit complicated. Not going to get into that here. But if you haven't filed within 30 days, then you also have to convince the court to hear your decision or hear the reference at all. And so you may end up having the case decided simply because they say, you filed too late, we're not going to hear it. But that 30 days only starts when you get a notice. And we see that a notice has to be in the prescribed form. So what we have here is something that's telling you that your registration certificate has been revoked, or they use the word nullified, which is probably avoiding the word revoked. So they're telling you that it's been nullified, but is this a proper notice? I don't really know. And I say that as somebody who's a firearms lawyer. We're put into a difficult situation here where we don't know if this is a proper revocation or if it's not a notice. So this creates a very difficult decision in terms of whether or not you want to file a challenge, whether or not you want to wait. Now, this does appear to be somewhat similar to a previous case, and I'm going to be tooting my own horn a little here because that previous case is called Runkle v. Alberta. And that's not a coincidence. This was my case. As much as I tell people you should get a lawyer for this, I went and ran this case on my own, which is something we generally consider to be not a good idea. But I'm in a bit of a better situation than most people for this. What had happened in that case is that the chief firearms officer had decided that they were going to take gunsmiths off of all the long-term authorizations to transport, as well as several other places. I didn't like that, so I immediately applied for a new authorization to transport that would include all of those places once again. What they did was they issued me an authorization to transport that didn't include all of those places, but included some of the places I'd asked for. Now, that was a bit of a problem because in my view, they had refused the authorization to transport that I had asked for, and they'd given me a different one instead, but they'd refused to grant me the one that I'd requested. They took the view that because they'd granted me unauthorization to transport, that they hadn't refused me. They got into a bit of difficulty in court on this because essentially they got pinned down a little, and what they ended up having to defend was the notion that if I asked for an authorization to transport to go to the range, and they instead issued an authorization to transport that only allowed you to take the firearm to the police for disposal, they said that wouldn't count as a refusal and that they wouldn't have to send you a notice in the proper form. The court didn't agree with that, and so they had found that that was a refusal. Now, this is good law in Alberta, but it's probably also persuasive elsewhere. And I'd suggest it just makes sense. If you ask for something and they do something else, that should count as a refusal. Similarly, in my view, and I don't think that they can dress up a revocation as a nullification here. I think that this is an attempt to revoke your license, but it seems, or to revoke your registration certificate rather, but it seems that it's an attempt to do so without following the proper procedures. So again, we don't know if this is a proper notice that would start your time limit, or if this is something else. It might just be invalid entirely, in which case it doesn't cancel your registration certificates. It's very difficult to tell how a court is going to deal with this. And it's going to be ultimately, somebody is going to be stuck in a long and expensive fight over this. So hopefully that's going to be somebody who's represented by able counsel. And the reason I say that is that I have a concern that somebody's going to run this challenge. They're not going to know the law. They're not going to know how to defend themselves in this challenge. And they're going to lose. And then that decision is going to be used as a weapon later against other challenges. So I would suggest that if you're looking to fight this, definitely talk to a lawyer. But ultimately, I'm not able to control anybody, but you should always talk to a lawyer if you're looking to go into a courtroom. The other thing that happens when they give you a proper notice of revocation is that they're required to give you a reasonable period of time to lawfully dispose of the firearms. So what counts as a reasonable period will really depend on the circumstances. However, the interesting thing is that if you bring a challenge under Section 74, that reasonable period is deemed not to start until that challenge ends. So if you win the challenge, then you don't need to worry about the reasonable period to dispose of your firearms because you've won. And if you lose the challenge, then you still have time to deal with it. But the more important thing is that while you're running the challenge, you don't instantly become a criminal. You don't instantly become somebody that they can arrest or kick in your front door just because you're trying to fight for this. Because ultimately it may turn out that the chief firearms officer's decision was wrong. And so if that's the case, you don't want to, it would effectively reduce or eliminate in many cases the reason why you bring the challenge. If they say, we want to take your guns away, and you're saying, I have $10,000 in guns, I really don't want to lose them. But while you're waiting for the challenge to be heard, the police have seized those guns, they've charged you with a criminal offense, and they've chopped the guns up. You don't have a whole lot left to fight over. So that's really what that provision provides for. By circumventing the standard notice, it circumvents this reasonable notice period. Now, they're going to say, of course, that the amnesty period is going to count for that, but that doesn't mean that they shouldn't be following the proper notice of revocation procedures. So if you're wondering how to fight this, either because you're a gun owner who's affected, or a gun owner who's worried that it might be you next, or somebody who just disagrees with what's happening here, what I would suggest is support one of your or all three of the firearm organizations. I understand that they're all running challenges here. They're all going to need your support, and that's one way you can make a meaningful contribution here. Thank you for watching, and I hope that this has been informative. If you have any questions, either things that you feel I didn't answer in this video or things that you'd like to see in a future video, please leave a comment. As this is a new project, I would appreciate it if you're willing to subscribe. There will be new videos coming out. I'm not sure yet as to the frequency, but we'll see as to how that goes. Again, this is my first video. I would very much appreciate comments, either positive or negative. I'm also leaving a link to a Patreon. It's there as a virtual tip jar. I've been asked to create one by people in the past. I'm at this point going to ask that you not donate to it. And the reason for that is that if you're an affected gun owner or you want to contribute, send your money to one of the firearms organizations. I'm doing all right. I don't need it, but it's there if you want to. Again, what I'd really prefer is just if you're willing to subscribe, if you're willing to hit the thumbs up or the thumbs down if you didn't like it, and if you're willing to leave comments. Thank you again.